Okay, good afternoon, everybody. I'm Brian O'Riordan, the Registrar of the College of Audiologists and Speech Language Pathologists of Ontario. And joining me today is Priya Singh, Director of Professional Conduct and General Counsel for CASLPO. So today's e-forum is on CASLPO discipline decisions you should know about. So we're going to cover a number of items today. So we're just going to put a little agenda on the screen for you. So we're going to talk first of all about what is professional misconduct. What is the definition legally of it, and how is that then applied? We're also going to review 3 recent discipline cases that have come before the discipline panels of the college. They are titled CASLPO versus D'Onofrio 2018, CASLPO versus Thomas 2018, and CASLPO versus Burge 2015. For each case, we will be discussing the facts, what the discipline panel found by way of a finding, a determination, in other words, the penalty that they imposed on the member, and the reasons for that penalty.
Before we get started, we'd like to ask that any questions that you might have, if you could enter those into the appropriate box on your screen. We do have Alex Carling, our Director of Professional Practice, with us today, and she will be fielding those questions. And if I can take a moment, Brian, I'd like to address one item that you may find surprising on the presentation today is that we have identified the members' names with respect to the discipline decisions that we will be discussing. The reason for this is that the Regulated Health Professions Act actually requires the college to report these discipline decisions in a public forum. Legally, the college is required to report this information on the annual reports, as well as any other subsequent publications. And so that's why you will see the member's name throughout these presentations. It's also important to remember that discipline is a matter of a public record, and so the college does not have the authority to hide or withhold that information, and that this requirement is actually consistent across all colleges. All health colleges have this requirement to report this information and to make it publicly available. And I turn it back over.
Okay, well, thank you very much for that clarification, Priya. So the first topic, as I said, that we're going to be discussing is the definition of professional misconduct. So I'm going to turn it back to Priya to take us through that, to give you an appreciation of the context in which the discipline panel makes its decisions.
Thank you, Brian. So every health college has its own definitions for professional misconduct. CASLPO specifically has a professional misconduct under Ontario Regulation 749/93 that identifies 37 different heads of professional misconduct. So essentially, its misconduct is actions or conduct that is deemed inappropriate or not proper for the practice of the profession. You have an example on your slide where it is an act of professional misconduct to submit an account that is false or misleading. Essentially, that's conduct that is not appropriate in practicing the course of the profession, and you will likely find a similar head across all health colleges. The Regulated Health Professions Act, the RHPA, sets out further acts in which all healthcare professionals are not permitted to engage in. So for instance, sexual abuse of a patient is prohibited under the RHPA, and this is a rule that is required of all healthcare professionals. Interestingly, the RHPA does not define professional misconduct, and this is principally because professional misconduct is dependent upon the profession, and so it's based on the consensus and values of that particular profession. So for speech language pathologist and audiologist, your list of 37 different acts will be different from, say, the act of a kinesiologist or a nurse.
Okay, thank you very much, Priya. So we're now going to move to the first case that we're going to be examining today, and that's CASLPO versus D'Onofrio 2018. So I'm going to review the facts in the case. First of all, in this case, the member was a speech language pathologist She treated a patient who had suffered an intracranial hemorrhage, which resulted in the need for speech-language therapy. The member assessed and treated the patient over the course of approximately 6 weeks from the period December 2014 until January of 2015. At that point, the patient was then discharged, and the member did not continue to provide treatment after that. But sometime between mid-February 2015 and mid-March 2015, the member and the patient engaged in a sexual relationship. The member ended the relationship around September of 2015. Then the patient lodged a complaint with the college in December of 2016. The complainant then indicated about a year later in December of 2017 that they wished to withdraw the complaint. In this particular case, the member admitted to engaging in professional misconduct by entering into a personal and sexual relationship soon after the therapeutic relationship had ended. Now, those are the facts in the case, and I'm now going to turn it over to Priya to take you through how the discipline committee dealt with this case and what the finding was that they made.
Thank you, Brian. So at a hearing held on February 8th, 2018, a panel of the discipline committee found the member guilty of professional misconduct under Section 1, Paragraph 37 of Ontario Regulation 749/93. Essentially, the panel found the member guilty of professional misconduct in that she engaged in conduct that was disgraceful, dishonorable, or unprofessional. Specifically, the member was found to have engaged in professional misconduct in that she became involved in a personal and sexual relationship so soon after the treatment relationship had ended. In this particular case, the panel directed a penalty of a reprimand, a 4-month suspension of the member's certificate of registration, 3 months of which could be remitted should she complete remediation, a 2-year practice monitoring program, as well as $5,000 in costs. The panel's reasons for this penalty was that they were concerned that the member had failed to exercise good judgment and follow the college's position statement when engaging in this sexual relationship so soon after the therapeutic relationship had ended. The panel was further concerned that the member's behavior failed to recognize the impact of the possible continued power imbalance and the vulnerability of her former patient. In making this particular penalty order, the panel felt that the range was appropriate given the range of acceptable penalties in similar cases, so cases that are seen from other healthcare colleges as well as other regulatory boards generally, and that this penalty would not otherwise be contrary to the public interest. The important takeaway from this decision is that audiologists and speech-language pathologists must remember the inherent power imbalance that exists in that treatment relationship. Patients are vulnerable to this power imbalance because they are seeing the audiologist or speech-language pathologist because they are in need, and that places them in a position of vulnerability. And so it is always important for the audiologist or speech-language pathologist to behave in a professional manner. This case has particular importance because since this case was decided, amendments to the RHPA took effect as of May 1st, 2018. And so now the RHPA prohibits a healthcare professional from engaging in a sexual relationship with a patient within 1 year of the treatment relationship ending. This is crucially important because now this type of conduct would be considered sexual abuse of a patient under the Regulated Health Professions Act and can constitute mandatory revocation of a member's certificate of registration. Had the conduct in the discipline case occurred prior to or after the 2018 amendments, it's likely the penalty that we just reviewed would have been vastly different.
Before we take questions from the members, Priya, I was wondering if you could comment on one part of the case that people might be wondering about. At a certain stage in the proceedings, the patient actually indicated to the college that they wanted to withdraw the complaint. Is this something that had a bearing then on the case? How did the panel deal with that request?
So when a request comes in from a complainant in which they want to withdraw the complaint, it does not automatically mean that the investigation is closed. Once a complaint is lodged, the college retains jurisdiction over that investigation because there may be other factors at play from the complainant's perspective. In many cases, complainants may not want to see through the complaint because it may be psychologically or emotionally exhausting for them. In this case, because the conduct was of such a serious nature, the college proceeded with the investigation, and the Inquiries, Complaints, and Reports Committee made the referral to the Discipline Committee to hear the allegations.
Hey, thank you, Priya. Alex, are there any questions that have come in from the audience?
There are no questions at this time.
Okay, we're going to pause after each case to give you a chance to type in any questions that you may have. And we'll pause again at the end if there's any more general questions anyone has. So we will now proceed with the next case study. And this one is titled CASLPO versus Thomas, 2018. So the facts in this particular case were that the member, who was an audiologist, made improper OHIP claims, provided inadequate counseling to patients and follow-up care to patients who had received FM systems from the member, and in addition failed to keep complete and adequate records. For a period of 6 years, the member had used the OHIP billing number of a retired physician, in this case an otolaryngologist. OHIP provided remittances to the physician, who then remitted approximately 60% of the funds to the member. Further, for a period then of 2 years, the member provided FM systems to patients, and in some cases, these were not set up for optimal use with hearing aids. The member entered a plea of no contest with respect to the allegations brought forward by the college.
Before we move on to findings, I'd like to discuss very briefly what a plea of no contest is. So in this particular case, the member did not admit to professional misconduct, but in entering a plea of no contest, it admitted to the facts that were alleged by the college to have constituted professional misconduct. Now, this might seem a bit strange, but it is a legal right in which the member has and exercised in this particular case.
Okay, so thank you, Priya. We will now move to reviewing the findings that the panel made in this particular case. Go ahead, Priya.
So at a hearing held on April 3rd of 2018, a panel of the Discipline Committee found the member guilty of professional misconduct under the following paragraphs on your slide. Specifically, the member was found guilty of failing to maintain the standards of the profession, failing to keep records as required, signed or issued a document that was false or misleading, submitted an account that was false or misleading, and engaged in disgraceful, dishonorable, and unprofessional conduct. For this particular case, the panel of Discipline Committee ordered a penalty of a reprimand, a revocation of the member's certificate of registration, as well as $10,000 in costs. The revocation of the member's certificate of registration is quite significant, as this means he is no longer permitted to practice as an audiologist, use the protected title audiologist, or hold himself out as being entitled to practice in Ontario. The reasons the panel provided for this particular penalty was that they saw that the member had intentionally participated over a long period of time in a scheme to inappropriately bill OHIP for personal gain. He showed little regard for the citizens of Ontario who are in need of healthcare and who rely on these public programs, and that the conduct had brought the reputation of audiologists across the province into disrepute. The panel felt that the penalty was appropriate as it fell within the range of acceptable penalties in similar cases, again as is seen from other colleges as well as other regulatory boards, and that it met the seriousness of the misconduct to serve the public interest ultimately. An important takeaway from this particular case is that inappropriate third-party billing is a very serious offense. It impairs the ability of not only public, but also private programs to provide funding for patient care. Audiologists and speech-language pathologists bear the responsibility to bill in an honest way, and in doing so are trusted to help these programs continue to be viable for the benefit of Ontarians.
Okay, again, Alex, are there any questions?
No questions.
No questions. Okay, well, hopefully that means what we're providing is clear enough for you to understand, but please don't hesitate to raise any questions if you have them. So we're going to move to the next case, and I will again present the facts in this particular case, which is CASLPO versus Burge. So this member is an audiologist again, and she had used the title doctor since at least 2009. She did this over a long period of time in the course of providing or offering to provide healthcare to patients in Ontario. The member had referred to herself clearly as Dr. Brenda Burge, as well as many variations and abbreviations similar to this. And these appeared on her practice website, on her business cards, and on her business sign. I'm now going to turn it over to Priya to talk about this particular case, which, as you'll see, did stretch over a series of years. Go ahead, Priya.
Thank you, Brian. So at a hearing held on October 28th to the 30th, December 18th of 2014, as well as September 2nd of 2015, a panel of the Discipline Committee found the member guilty of professional misconduct under the paragraphs listed on your screen. In particular, she was found guilty of misconduct in that she had inappropriately used a title, term, or designation, that she had contravened the Audiology and Speech-Language Pathology Act, the Regulated Health Professions Act, and regulations thereunder, had inappropriately advertised or permitted advertising, and had engaged in disgraceful, dishonorable, or unprofessional conduct. The penalty for this particular case involved a reprimand to the member, 3 months suspension, 1 month to be remitted, 6 unannounced practice inspections, the completion of a remediation course, as well as $97,595 in costs. I want to take a moment just to discuss the matter of cost. You will have noted in the previous cases, the costs were substantially smaller than what you're seeing on the screen at this moment. The principal reason why the costs are much larger in this case is because the case went forward as a contested hearing. In cases where the college and the member are able to reach an agreement prior to appearing before the discipline panel, costs of holding that discipline panel are substantially reduced. So with respect to the reasons why the panel had made the penalty that they did, they felt the conduct was a clear violation of Section 33 of the Regulated Health Professions Act. Now that section specifically outlines the healthcare professionals who are permitted to use the title doctor in the course of providing care in Ontario. The panel also felt that the member's conduct displayed a knowing and willing breach of the regulations that govern the profession, and that importantly, for self-regulation to be effective, the member must abide by the current and relevant legislation. Simply because you do not agree with a rule does not mean that that's sufficient reason to not follow it. The order was meant to denounce the conduct of the member as well as to send this message to the membership generally. It provides both specific and general deterrence. This decision has application for both audiologists and speech-language pathologists, as well as all healthcare professionals subject to the RHPA, because all healthcare professionals are required to follow not only Section 33, but all the requirements within the Regulated Health Professions Act. The member had engaged in conduct that was clearly against the law. The restriction is created to prevent confusion by vulnerable patients with illnesses or health concerns. It should be noted that this decision has withstood a considerable amount of judicial scrutiny, as the Ontario Divisional Court has upheld the discipline decision, and the members' leave to appeal has been denied by both the Ontario Court of Appeal as well as the Supreme Court of Canada. However, I would note that a motion has been made to reopen the case, and while we will not be discussing that today, it will be heard shortly, and the college will provide updates as is appropriate.
Priya, again, before we go to the audience, could I just ask a couple of questions? I'm sure members were struck by the high amount of the costs that were imposed as a penalty against the member. Could you describe just a little bit what some of those costs might be involved in terms of the college, and why the panel felt justified in assigning such a high cost?
Absolutely. Costs that are presented to the panel include costs right from the beginning of the investigation. So there are costs that are incurred for an investigator to do an on-site visit. There are costs that are incurred potentially for some cases to provide an expert opinion. There are also legal costs. We do retain counsel to prosecute cases specifically, and that then turns into more legal costs, because once a matter is referred to discipline, the panel of the discipline committee also has the right to have independent legal counsel. And so that's a party that advises the panel specifically, does not advise college counsel, nor does it advise the members' counsel. The college is required to pay these costs. And so on average, I believe the cost of holding a discipline hearing per day can amount to almost $10,000 per day. The costs that were eventually ordered, I believe, constitute a fraction of the ultimate cost that the college had to pay. And so the college does not normally request full costs. As well, there's not much jurisprudence that would support full costs being obtained from the member. However, given the significant costs that were incurred in this particular case, a fraction of that became over $90,000.
Okay, thank you, Priya. And when you talk about the panels of the discipline committee, could you just talk a little bit about the composition of those panels?
Absolutely. Panels of the discipline committee are composed of members of the profession, so those who are elected members on council. They're also composed of members of the public who are appointed by the Ontario government to serve to ensure that the public interest is being met, and that is consistent with the college's mandate. From this committee, there is a section of members selected, and they sit specifically to hear a panel or to hear a referral. They are screened extensively to ensure that there are no conflicts of interest or bias present, so that they can adjudicate the particular case in an unbiased and fair way.
Okay, thank you. Alex, do we have any questions?
We do. We have a number of questions.
Okay.
So first of all, in CASLPO versus Thomas, who lodged the complaint against Thomas? If you are allowed to impart that information, I'm not sure.
I'm not 100% sure, actually. I can say that the college actually received information from the OPP. However, I hesitate with the question because not all cases that are referred to discipline result from a complaint. It can result from information that is provided to the college that would be initiated through a registrar's report. So conduct, for instance, that is received from the police department, we wouldn't require the police department to lodge a formal complaint against the member. It's sufficient for them to report that information to the college, and there is authority under the Regulated Health Professions Act for the registrar to then initiate an investigation. And I believe that is how the Thomas case started.
Yes, and I think there's more information about the Thomas case because, again, it was a very lengthy case, there's more information. If you go to the link at the beginning of the presentation, we're going to be making this presentation available on our website. You will be able to see more information there about exactly what started the complaint and how it arose in the first place. But there certainly was police involvement in this case, given the size of the alleged fraud.
Yes, absolutely.
So we have another question with regard to Donofrio, and the subject it brings up is about more of a social relationship. So the question is, what would be an appropriate length of time before beginning a purely social relationship with a client, or is it always counterindicated?
It's always the traditional answer is it's always dependent on the case. It really will depend upon the factors in that particular case, how vulnerable the patient is. If this is a purely social relationship, it's unlikely to fall within the boundaries of sexual abuse of a patient. However, depending on the circumstances, we always caution members to be extremely careful when they engage in that type of relationship with an individual who was their patient. That vulnerability is likely always present, and there's a very good possibility that that individual will always see you as a healthcare provider, and maybe subsequently a friend, and so that may color the relationship you have ultimately. Don't know if you have anything else.
Yes, I think this touches on something that we've been working on internally at the college over the past few months, and that's revising our sexual abuse prevention program. So we first put that in place in 2013, but because of the recent amendments to the Regulated Health Professions Act that Priya touched on briefly earlier, those amendments in 2018 certainly required us to take a look at our program and to revise it. So there'll be new FAQs made available to members once we have finally approved the wording in the program, which we anticipate will be within the next couple of months. Our committees have been looking at this matter quite closely. I think the member has raised a very important question about social versus sexual. The problem sometimes what we have seen in some of these sexual abuse cases over the years, not particularly our college, but certainly other college cases, is that sometimes the social, unfortunately, because boundaries are not respected by the member or in some cases the patient, those social relationships can morph into a sexual relationship at some point. So our best advice is always to be a little cautious about these kinds of things. Obviously, I think that boundaries need to be respected, and common sense has to come into play here often. But I think that we'll have helpful advice for members on these kinds of situations with the new sexual abuse prevention program when we roll that out in the next couple of months. But very good question.
So we have a question from a number of members concerning the use of the title doctor. That, of course, we know there is the professional doctorate for audiologists. There are also members, both SLPs and audiologists, who have PhDs. So what is CASLPO's involvement in allowing members to use the doctor title?
Well, there certainly is some guidelines that we can that we have for members in terms of the use of the doctor title. It is appropriate in some very narrow circumstances, which I'll let Priya elaborate on. But generally speaking, with respect to the clinical relationship, there are only 7 professions in Ontario that are given access to the doctor title by the Regulated Health Professions Act. This is a bit unusual, as we know, in terms of other provinces' approach to the doctor title, other US jurisdictions and their approach to it. But colleges have to apply the law as it is. and the law as it is restricts the use of the doctor title in Ontario to only 7 professions. And audiologists and speech language pathologists are not amongst those 7. That being said, there are some instances in which members can refer to themselves as doctor.
Yeah, absolutely. There is a position statement, if I'm not mistaken, on the college's website that discusses this in probably better detail than I can say at this moment. But if you are going to use your credentials with respect to the doctor title, the current practice advice is to use your name. So for instance, John Doe, followed by Doctor of Audiology. We don't encourage the DR title in front of your name.
As a prefix.
Exactly, because that is confusing, and it comes with the assumption that it is the title that is restricted within the RHPA. And so I would encourage any members who have more questions about this to review the position statement on our website and contact us directly if you have any specific questions. Perhaps you are looking at including it in a promotional item, a business card, and are wondering about the terminology that you can use. We'd be happy to have that discussion with you.
And certainly in academic circumstances where there's no clinical involvement with a patient, the title can be used, but again, it very much has to be a case-by-case basis for the individual involved. But it certainly is a very good question again, and we can certainly provide more information, as Priya said, about this, because it certainly does come up as a question in our practice advice program. So, okay. Any other questions, Alex?
Yes, yes. On one of the earlier slides, it talked about, I believe it's Donofrio, and the finding. It talks about 1 month remitted.
Oh, yes, right.
And please, could you explain that?
That was Burge.
Sure, absolutely.
That was the Burge.
The panel has the authority to provide a bit of variation within their orders. So in certain circumstances, a panel may feel that a 6-month suspension is appropriate. However, if the member demonstrates insight as to why the conduct was not appropriate, they may also demonstrate a desire to correct their behavior. And so the panel will give them the option of completing some sort of remediation program, for instance. And if they complete that remediation program within a set period of time, the panel can then leave in their order that should that remediation be completed, a part of that suspension can be remitted. And so you'll see actually that particular clause, if you will, in a number of discipline orders, because panels do like to give the member the opportunity to learn from the experience. Discipline decisions are not only supposed to be deterrence, they're not only supposed to have a certain punitive element, it's also supposed to be remediative. It's also supposed to provide the member with an opportunity to grow and move past the conduct and learn from their mistakes.
Okay. Anything else, Alex?
Yes. Where did CASLPO get the funds to pay the lawyers in the, for example, in the Burge case?
Sure.
Or it could be any discipline case. Where does CASLPO get the money to pay for this?
Sure. Well, I'll talk a little bit about the process. Again, a very good question. There's a lot of costs that the college has that are predictable. We can, based on the membership revenue for a given year, we can then predict fairly accurately, based on past history and past financial support for certain areas, what our costs will be. So for instance, if you look at an area like registration, we know that there will be certain costs relating to the registration process each year. Similarly with quality assurance and the self-assessment tool, we can have a pretty good idea of the costs. Those members who act as peer assessors We know their costs in terms of travel and honoraria, etc., that they're paid to do their work as peer assessors. So there's a predictability about those kinds of things. But then there's other areas like the complaints process where it's a little more unpredictable. So we try to work with our director of finance each year to allocate sufficient funds to cover the costs of external legal counsel. So we do know that we, on average, are getting about 30 to 40 complaints and reports being made to the college each year. We know that a certain number possibly are going to be more complicated or more serious or may result in discipline, based again on past history of decisions being made by the panels. And so we can try to set aside some funds within our budget for that. We don't get any special funding for this. There's no government funding. All funding for the college activities, including funding for the complaints process and for external legal counsel, have to be drawn from the membership fee revenue, which we receive each year from all of you out there. So I hope that answers the question, Alex, but if people wanted to look further on the breakdown of costs, they can certainly consult with is sometimes a little bit of a hot button issue with certain colleges. Has not come up really a lot at our college, but certainly another good question. But go ahead, Priya.
Absolutely. So right now there is no exemption for treating your spouse. The Regulated Health Professions Act does not permit the treatment of spouses by a healthcare professional unless there are specific regulations in place from the college to permit this. As far as I'm aware, there's only one health college who has successfully obtained regulations in this regard, and that would be the dentist.
That's right.
No other college has received approval of these regulations, and so treatment of spouses is not prohibited or is not permitted under the RHPA.
Okay, thank you. And just going back for a moment, Alex, to the previous question on costs, I would just add that because sometimes there are significant costs involved in the college prosecuting a particular case, that the college does try to recover as much as it can some of the costs directly from the member. We're constrained a little bit by precedent in terms of what previous panels of our college have done in the discipline process, but also constrained a bit by findings and penalties imposed in other colleges, by other colleges in similar cases. But as you saw in the Burge case, we felt that there were such significant costs involved that that was part of the penalty that the panel was able to impose. Okay, anything else, Alex?
Yes. Back to the doctor title. A couple of things. Number one, is it true that naturopaths and homeopaths are able to call themselves doctor?
With respect to homeopaths, no. With respect to naturopaths, their previous legislation allowed them access to the title doctor, and so they were not originally under the Regulated Health Professions Act at all. That changed about 6 or 7 years ago. So they are still allowed to use the doctor title. It's a bit of a peculiar kind of interaction between their previous legislation and the Regulated Health Professions Act, but they do have access to the title. I think there are certain restrictions that the college imposes themselves on the use of the title, but in the case of homeopaths, no, not at all.
Okay, thank you. If just someone wanted confirmation that you can use the doctor title in the field of academia and research, yes, when you are not providing intervention to a patient caseload.
Yes, absolutely. You can use the title doctor in the field of academia as long as you're not providing direct care to patients.
Right. If someone who, let's say, is an audiologist, can they use the doctor title to book a flight and do something completely unrelated to the provision of healthcare?
Yes, I can't imagine that would cause problems. I say that with the caveat of I have received very strange complaints in my time. So it is always important to note that anyone has the right to make a complaint against a healthcare professional. And so we always encourage members to conduct themselves in a professional and appropriate manner. However, if you are flying and feel that it is appropriate to use the title doctor and conduct yourself in a professional manner, I can't see how that would be problematic.
Well, two comments. I think the word problematic is the best way of looking at this because while somebody may register themselves with the airline as doctor, airlines do take note of this. So for instance, if there was an emergency on the plane, and the usual thing is there a doctor in the house, and you're not really a medical doctor, the person doesn't have a communication disorder problem that you can deal with, the airline is simply going to often assume that you are a medical doctor and may call you out on that. The other thing to just be careful of with all of the new and intense screening that go on in terms of border security is, again, once you have indicated, as I understand it, that you are a doctor of some kind, special notation is going to be made of this. And again, there may be an expectation that the authorities have with respect to your use of that title. So I think you have to be careful about it, but the language in the Regulated Health Professions Act is very clear on who has access to use the doctor title in the clinical setting. And that's the most important thing always to observe.
So we have a number of questions of people who would like, from members who would like clarification about relationships, social relationships with patients, extended family, etc. They're saying they might be from a very small community where they will know the patient's extended family, you know, sometimes extremely well. You know, they understand, you know, they have to be very careful with the patient. Is there any guidance, and is there any guidance about a timeline? So, for example, the ministry said 1 year for a sexual relationship. Is there any timeline, and what do you do about smaller communities where you are well known and you have relationships with extended family members?
Absolutely, and we appreciate that in smaller communities it can be very difficult to maintain that private professional boundary. As we said earlier, it essentially depends on the circumstances of the case. The responsibility is on you, the healthcare professional, to exercise your judgment with respect to whether the relationship is appropriate or not. So, for instance, you may have a cordial relationship with an individual and see them at the grocery store every Saturday morning because that's your routine. You know, there's nothing that would necessarily restrict you from saying hello and having a polite conversation. That can be seen as a social interaction. You know, and then obviously social relationships can expand from there. And it is, again, your responsibility to determine whether it's appropriate or not. It's important to gauge the vulnerability of that patient, potentially the dependency that they might be exhibiting. And as we mentioned earlier, it's also important to remember that that particular individual may always see you as their healthcare professional, may rely on you and your opinion more than they might, say, an average regular friend in another circumstance. So these are very vague, unfortunately, guidelines that we can provide without context to a specific case. So the takeaway is ultimately to encourage you to exercise that professional judgment, because it is very difficult for us to define specifically you should be able to engage in a relationship, say, in 1 year or 3 months or 5 years, because it will always be dependent upon the circumstances of the case. And I can't stress enough the vulnerability of that particular patient.
So we're nearing the end of the number of questions coming in. I would like to say we've received 2 questions that I consider to be very complex legally.
Okay.
So in situations like this, we have the question and the appropriate person will get back to the member via email.
Absolutely.
Okay.
So
right.
I believe that there are 2 here. But there is one question actually from a number of members. Can CASLPO do anything about advocating for the use of doctor title with the ministry?
Sure. So the college, along with many other colleges, I think virtually all, back about, I'm thinking now, 12, 13 years ago, when this question arose because of a situation regarding a referral to the Health Professions Regulatory Advisory Council concerning possible amendments that might be made to the Regulated Health Professions Act. And when the Advisory Council looked at the question of whether there should be greater access to the title doctor, colleges were generally supportive of being more in line with the practices and the approaches in other provinces in Canada and the US. In other words, to allow more professions to have access to the doctor title. In fact, the Advisory Council to the Minister did make that recommendation that the Ontario government should loosen its approach to the use of the doctor title within Ontario. However, the ministry rejected that advice and has not revisited that since, as I say, about 12 years ago. So has it come up as something that has been a priority for the ministry lately? I would have to say no. They have opened up the Regulated Health Professions Act a number of times since 2007. They made changes in 2009, 2014, 2018, but they have not touched this particular area. Colleges do occasionally, excuse me, still raise the issue. It is something that the Federation of Health Regulatory Colleges of Ontario, of which CASLPO is a member, could consider again. But to be very candid, it hasn't arisen as a major priority within regulatory circles now for a number of years. And the reason for that is fairly straightforward, in that the ministry and the colleges have been much more involved in such things as trying to get changes to professional scopes of practice, looking at how colleges can be more transparent and open in terms of their processes and the information which they share with the members of the college and with members of the public. And as Priya was mentioning most recently, a very considerable focus by the ministry and the colleges on the prevention of sexual abuse of patients by members. Right now, the ministry is exploring ways in which it wants to receive more information about the internal metrics showing how the colleges are indeed fulfilling their role as protectors of the public interest. So it's a good question. I don't know if it is going to arise anytime soon again. However, if the act is, the Regulated Health Professions Act is opened, it is quite possible that issues like that may come forward. There certainly has been in the past considerable resistance from the 7 or so professions that are allowed to use the doctor title. So there's not going to be unanimity around any movement by the ministry in that direction. The Ontario Speech, Language and Audiology Association, of course, would be much more likely to, I think, be able to take a leadership role on this matter, and has certainly advocated for it in the past, as have other associations relating to other professions.
Priya, we've had a question, and thank you, Brian.
Yeah.
We've had a question for you. When the discipline panel fine a member, and you've gone over the different fines, do the fines have to be paid before the member can practice as an audiologist or speech language pathologist?
Normally, costs are not tied to a member returning to practice. So there is many cases where a payment schedule is set up. For instance, if you were fined $5,000, you may make the payments $1,000 each month or every other month. And so normally this isn't tied to returning to practice. It's normally in relation to the college's ability to recover some of the costs that they've had to expend in order to discipline that particular case.
Excellent. So I think we've come to the end of the questions. I would like to repeat that we have had a couple of questions that are legally complex. So I'm sure Priya and Brian will put the mind and will contact the two members with answers to their questions.
Absolutely. So maybe we can just go to the end then, Priya. And so it leaves me to simply thank you all. I think it's tremendous to see the number of people that have attended this forum. I hope we gave you some valuable information. Whenever you get into these sorts of complexities, of course, sometimes you feel like you're only scratching the surface. but there are many other resources relating to discipline and complaints on the website of the college. If you need to contact Priya or myself directly, you have that information there. Certainly would also urge you to follow us on social media. Of course, the resources section of the website has many valuable resources and has information relating to all of the parts of legislation and regulations that we mentioned today in our presentations. Also, frequently there are articles in the college's publication, Express, and certainly you can see information about cases and valuable advice about preventing getting into the complaints or discipline stream as a member. So I would urge you to take a look and avail yourself of all of those as well. In addition, this particular e-forum will be appearing on the website. So if you want to view it again, or if colleagues of yourself want to view it, certainly we will be making available to you the information about how to access that as well. So I think we will, and in addition, the slides which we've used today, the PowerPoint we've used today, that will also be posted on the website for your reference. And as Alex mentioned, if there's those questions that are a little more complex, we will certainly get back to those members. And if you have questions that arise afterwards, as you think about some of this, please feel free to contact us and follow up with us. And at any time, if you have questions about something that has arisen in your practice that you're not certain about, our practice advisors at the college, both for speech-language pathology, such as Alex, or audiology, such as Samita Jalkar, are always available to take your questions or emails and follow up with you. Our job is to keep the public safe, but we also realize we can only do that in cooperation with and collaboration with all of you. So please do use the resources that are available, and please do follow up if you need to with us at any time. So thank you again. Any last words, Priya?
No, just thank you very much for participating today. All of the discipline decisions are available on the website, and links should be embedded in the slides in case you'd like to read them further. And as Brian has indicated, if you have any questions, please do not hesitate to contact us.
Okay, thank you all very much.